And let's continue. Article number 8, employment contract, and paragraph 1 of Article 8. The employer shall conclude an employment contract with the worker according to the agreed work pattern. The contract shall be made in 2 copies. One copy shall be kept by the employer and the other shall be handed over to the worker as per the forms specified by the implementing regulation hereof. Okay, so what the particular paragraph says, if a worker agreed, if an employer agreed with a worker in let's say in a part-time work agreement, then the agreement should be binded in a formal contract. The formal contract will be in 2 copies, one for the employer and another one for the worker, for future reference and for future disputes. Let's continue. Paragraph number 2. The worker or his representative, for example, his lawyer, may prove by all possible means of proof the employment contract, the amount of the wage, and any of the rights he is entitled to receive under the provisions of this degree law, its implementing regulation, and the resolutions issued for its implementation. The employment contract, the amount of wage, and any of the rights. Let's read the particular paragraph for a second time. So, the worker or his representative, again, for example, the worker legal counselor, may prove by all possible means of proof the employment contract, the amount of the wage, and any of the rights the worker is entitled to receive under the provision of this degree law. I am not sure what the particular paragraph might need to identify, because in my opinion, in a formal contract, any necessary information is included on the contract. For example, the working hours per week or per month, the gross let's say yes, the gross salary per hour or per month of the worker. So I believe what might the particular paragraph might want to say is that the worker should be able at all times to prove certain conditions of the contract, such as the amount of the wage and any rights that the worker was entitled according to the particular contract, under the provisions of the particular employment law. Article 8, employment contract, paragraph 3, contract of employment shall be concluded for a specified period of time, subject to renewal in accordance with the agreement of both parties. There is an asterisk. In accordance with federal Decree Law number 14 of 2022 regarding amending some provisions of Federal Decree Law number 33 of 2021 regarding the regulation of employment relationships. So the particular passage paragraph points us to the Federal Decree Law number 14 of 2022 regarding the amending, that means regarding the change of some provisions of the Federal Decree Law of number 33 of 2021. So for the particular paragraph, there might be some changes in a newer law amendment. So in a later amendment of the particular law. So we need to clarify the particular changes, and the reference point to clarify the particular changes is the Federal Decree Law number 14 of 2022. So amendment in essence is a document that includes a change in a former, in a particular law document. And again, contract. Give me some time. Let me say it again. Contract of employment shall be concluded for a specified period of time, subject to renewal. So, any contract of employment is valid for a specified period of time and is subject to renewal. For example, based on the worker key performance indicators and the employer willingness to renew the particular contract. Let's move on. Paragraph number 4. In case of extending or renewing the contract, the new terms shall be considered an extension of the original term and shall be added to it while calculating the worker's continuous term of service. So in the case that the performance of the worker was, let's say, exceptional, and the employer is wishing to renew the contract of the worker, then any new terms introduced in the new employment contract shall be considered an extension of the terms introduced in the original contract, and should be added and shall be added to it while calculating the worker's continuous term of service. Again, I am not sure what the particular paragraph is, what is identifying the particular paragraph. Again, paragraph 4, in case of extending or renewing, the contract, the new terms or term shall be considered an extension of the original term and shall be added to it while calculating the worker's continuous term of service. As I understand what the paragraph 4, as I understand, the meaning of paragraph 4 is that the context of the original contract remains the same in the renewal period and maybe introduced new terms. So it's the original contract. If the employer wishes to renew the contract, that means to offer an additional contract, a second contract to the worker, then the employer may introduce the same contract and in addition introduce new terms to the renewal contract. And I try to understand what is meant by saying while calculating the worker's continuous term of service. The continuous term of service might be related to the working contract, but in essence what paragraph 4 says is that in the case that the employer is wishing to introduce a second employment contract to the worker in the end of the original working contract, then he might do so, introducing the same terms and conditions introduced in the original contract, plus the employer have the option to add additional new terms in the newly introduced contract. And in the newly introduced contract, the employer will have let's say, the opportunity to calculate the worker's continuous term of service. Let's continue. Article 8, employment contract, paragraph 5. If both parties continue to implement the contract after the expiry of its original term or the completion of the agreed work without an express agreement, the original contract is considered implicitly extended as per the same conditions set forth therein. Let me read it again. If both parties continue to implement the contract after the expiry of its original term or the completion of the agreed work without an express agreement, the original contract is considered implicitly extended as per the same conditions set forth therein. So the particular paragraph says the following. If okay, I'm like this because I am somehow tired, let's say. So paragraph 5 says the following, that an employer and the worker may continue their relationship, their work relationship, without the immediate addition of a new contract. But in this occasion, are valid the terms and conditions of the original contract. For example, as I understand from the particular paragraph, from paragraph 5, let's say, let me have some Coke, okay. No. So, for example, let us assume that I was able to land the golden call for the role of the Emirates cabin crew, okay, and I was able to conclude the first 3 years contract. Then, in the late stages of the first contract, Emirates offered me the possibility to remain to the company in the role of the Emirates cabin crew for an additional 3 years. Let's say that verbally I agree with a particular possibility. Maybe I was able to give my return concern, let's say through an email. Let's say a representative of the Human Resources Department of Emirates sent me a formal email saying that, Konstantinos, would you like to stay to the company for an additional 3 years? For an additional 3 years term. And I said, yes, I will be more than happy to do so. In this occasion, we have an agreement through an email reply and through a phone call reply, let's say, but not a contract, a formal contractual agreement. In that occasions, that the employer and the worker are more than happy, let's say, to continue their cooperation. There is not any need to introduce immediately a renewal contract. That means the worker will be able to remain in the service of the employer until the newly contract is introduced, until the newly renewal contract is introduced to the worker. So that's why the paragraph identifies that if both parties continue to implement the contract after the expiry of its original term or the completion of the agreement work without an express agreement, without an immediate agreement, the original contract is considered implicitly extended as per the same conditions set forth therein. So you see, that's why we see in paragraph 4, in case of extending or renewing the contract, the new terms shall be considered an extension of the original term and shall be added to it while calculating the worker's continuous term of service. Because in the particular scenario, let's say I said yes to the possibility of me to have a second term with Emirates, but because the renewal contract was not introduced yet to me, that means even though the existing contract had been expired and I had only given my approval for a second contract through a phone call or through an email, a formal email reply, let's say the valid agreement will be the terms and conditions of the first contract, of the initial contract. Why? Because the renewal contract was not introduced yet to me from the employer. I believe it's clear what I tried to say and what the law says. And finally, after 22 minutes, Article 8, paragraph C. Subject to clause 3 of this article, the implementing regulation hereof shall specify the forms of employment contracts according to the approved skill levels and the provisions for changing the contract form the provisions for changing the contract from one work pattern to another and register them at the Ministry of Human Resources and Emiratisation. So there are various forms of employment contracts according to the approved skill levels of the workers. Let's move on. The final part of this video is Article 9, probationary period.